Duxbury, Massachusetts, a quiet seaside town, was shattered by an unthinkable tragedy. Lindsay Clancy, a young nurse, devoted wife, and mother of three, was seen as the picture of perfection. But police say behind the smiles and family photos, darkness took hold. On a cold January night, investigators say she strangled her children, Cora, Dawson, and baby Callan. All that before attempting to take her own life. Clancy's husband, Patrick, returned home to a scene of unimaginable horror. Now, the once trusted nurse faces murder charges, as her defense claims she suffered from severe postpartum psychosis. Prosecutors call it calculated. Her attorneys say it's a symptom of a mind lost to illness.
Welcome back to Court TV Live. I'm Cody Thomas. Major developments in the Lindsay Clancy case. Finally, on day 4, we have a jury of 18, 12 women, 6 men. 12, of course, deliberating with 6 alternates, making that total of 18. Now, there was some confusion earlier this morning, but we now have confirmed we know they are ready to go with that panel of jurors. And there was lots of action in the courtroom today. We'll see some of that in a moment regarding a hearing on behalf of Lindsay's ex-husband, Patrick Clancy. But we do know that Lindsay Clancy's parents were there today, hanging their heads as graphic evidence was discussed regarding those 3 beautiful young children who were murdered. But first, let's talk about jury selection. Bringing in our guest this hour, criminal defense attorney Ali Benevento and law enforcement expert Sonny Slaughter. First of all, y'all know I love a good ladies' night here on the program. Great to see you both. Love having you guys on. What better guest to have on talking about this? Ali, I'll begin with you. Just want to get your thoughts on this jury selection here today. 12 women, 6 men. What do you the demographic here? Do you think that's going to be advantageous with, the amount of women versus men based on the nature of this here, dealing with postpartum depression and psychosis? What are your thoughts?
Yeah, absolutely. I love that we have, as a defense attorney myself, I love that we have so many women on the jury. I think that any woman who has gone through pregnancy and delivery, and specifically ones that have experienced postpartum depression, even if they haven't experienced that psychosis that we know that the defense is going to raise here in this case, I think that they can be particularly sympathetic to Ms. Clancy. And I think that that was a great move on the part of the defense. I like the makeup of this jury. Haven't seen them yet, but love to see all the women on the jury. I think they can be good listeners.
Sonny Slaughter, I want to get your thoughts as well. Do you echo those same sentiments?
I do. Great to be with you, Cody. Great to be with you, Ali. Nice to meet you for the first time. And I absolutely agree. I work both as a prosecution and most often as a defense expert. However, I do think the lens, language, and understanding of the women on the jury will have a different and unique component to this. However, I will not discount the men on this particular case, because men who have had wives, girlfriends, and other women in their life who have had postpartum depression and not necessarily psychosis will have some kind of understanding if they were involved in the comfort and care of these individuals. Also, really quick, I want to point out the fact that culture plays a role in how people identify postpartum depression and psychosis, how they talk about it, if they talk about it in their families through that particular lens and understanding. Culture will play a huge role in whether people, they will bring their lived experience to this, but we do want them to focus on the evidence.
Absolutely. And Ali, especially when dealing with a case as meticulous as this one involving mental health, people, I imagine the prosecution is probably looking for some people that aren't as sympathetic to mental health issues, while the defense is looking for those who are more so advocates, I should say, for people that are suffering from mental illnesses.
Yeah, absolutely. I mean, the prosecution, we expect their theory is going to be that this woman was a cold-blooded, premeditated murderer, that she planned this, that she was meticulous in what she did, that she got her husband out of the house. And they want people to take a no-nonsense approach. They want those people who are in the internet comment sections saying, let her fry, put her under the jail. There's no excuse for a mother that would take the lives of her children. But I have to say, from what I've seen, it does appear that she has a good bit of sympathy. And it makes me wonder, the makeup of this jury, what people on that panel are going to side with, sympathy, and which ones are going to be in the put her under the jail category. It'd be really interesting to see. But certainly the prosecution wants those jurors for sure.
Yes, Sonny. I've been looking at all the social media comments regarding this case for the past few days since jury selection has been going on. I mean, even prior to that, we're just in discussing this case, this trial coming up. Do you imagine it's going to be, when it gets down to that time for deliberation, it's going to be a pretty torn, maybe down the middle type of argument or deliberation situation? I mean, I wouldn't be surprised, if this could maybe end up in a hung jury in some regard.
Oh, yeah, absolutely. I agree with that. I literally just got attacked for my post. I focus on education and enhancement in my post around these issues. And I was attacked, from somebody who was saying we wouldn't even think about this if it was a guy. Well, to my knowledge, men don't have children. They don't suffer from postpartum depression or psychosis. So I think there is the possibility that this could be a hung jury, because those that focus on the emotion will be thinking about, well, you know what? She could have stopped doing this. She did it intentionally. And those who want to focus on the evidence, who have experiences, then they might say, you know what? I am sympathetic. And when we start hearing the evidence, remember, everyone, Cordy's, we have not even heard the evidence. She has admitted guilt, but we haven't heard the actual evidence. And I think the drugs and her history of medication is going to play a substantive role in how people see this case and how the case plays out in the end.
Absolutely. Now, Sonny, next time somebody attacks you, better send them my way now. We don't need any Sonny slander going on out here on social media.
Sonny, we might have some of the same followers.
You see, and listen, all three of us included here. Sonny and Allie, y'all are standing by here real quick. Let's get our viewers back to that motions hearing where we left off. Patrick Clancy's attorney was asking the judge to keep the 911 call and evidence that included the children from the public. Let's hear what the prosecution has to say.
With regard to the 911 call, Your Honor, I believe it's a public record available on a public records request, but I would defer to the court in terms of how you want to restrict publication of the 911 call during the trial or thereafter, as long as the Commonwealth is still allowed to show or play, rather, the recording for the jury, as the court has previously allowed that motion. Regarding photographs of the children, we had already addressed the autopsy photographs. The Commonwealth was going to request impoundment of those, and we would agree that they should not be broadcast or photographed in any way. Crime scene photographs, the children had already been removed from the home when the crime scene photographs and video were taken, so they will not appear in those photographs. The only blood in those photographs would be the purported blood of the defendant in the bedroom and on the exterior of the home, and then a small amount of blood from Cora in the basement. In terms of pre-incident photos, there has been mass publication of photos of the children already, but I would defer to the court on that as well. And regarding the clothing of the victims in this case, the clothing would be a shirt and pants that Dawson was wearing, pajamas and a bathrobe that Cora was wearing. There's a small amount of bodily fluid on the pajamas, and then pajamas that Callan was wearing. But although some of the material has been cut as they were cut away from the children, as EMS were working on them, trying to save them, there's nothing about the clothing that I think would suggest the need for restriction of publication of those items. So that's the Commonwealth's opinion.
All right, Counsel, thank you. Attorney Reddington?
Let's call a spade, Judge. I have been in this court every time we've had pretrial hearing indicating to the court that the circumstances of the death is not in dispute. The circumstances of this horrific act are not in dispute. Repeatedly, the government has argued that they have a right to try their case, to present their evidence. Sure they do. But, you know, even though we're in a court, let's talk a little bit about humanity. Let's talk a little bit about how we should try this case. I have indicated repeatedly that we stipulate to every piece of evidence that they want. I have respectfully objected to you with the introduction of the stuff going into the trial, I understand your ruling, and quite frankly, it makes sense. You're trying a case. What I can't fathom is the district attorney's intent to put a circus in front of this jury that's calculated to just inflame the passions of the jury, repeatedly placing in evidence items such as having Patrick Clancy, who's a young man who has suffered one of the worst tragedies that anyone could ever suffer. How that guy is still not an emotional basket case is beyond me, and he has been. But nevertheless, he is trying hard to move on with his life. He has, as the court is aware, they're divorced. He's remarried. He has a family. He has his extended family. Your Honor heard statements, and I know for a fact that it's true, that his family, totally innocent people that have nothing whatsoever to do with this case, are being harassed daily by news media, the New York Post, and all the rest of these types of salacious news media outside their door. This is his family. Some of them are in California. They have nothing to do with this case. But nevertheless, they are being hounded by the media. And the district attorney wants to put that guy on the witness stand and show little onesies with bodily fluid of his child, and they want to have him stand there, or they're going to let him stand in the hallway while we listen to the 911 call.
Mr. Reddington, that's another issue. That's another motion. The question we have right now, respectfully, is Mr. Myers' request as to how we should deal with this in regards to the media.
I agree with Mr. Myers' request, as I told you with the sidebar. I think it's very appropriate. I think he argued it effectively. I think that Your Honor is well aware that you have the authority under the SJC rules to enter limiting orders, if you will, as to publication, as to what media can publish, what photographs they could look at and report. And I agree with what he had indicated to you in his argument.
All right. All right.
But I still want to say that I think it's reprehensible the way the government is trying this case.
Your Honor, if I may, I'd just like to say that I understand why defense counsel would want to brush past what happened to these children, whitewash away what happened, and focus on something else.
Here's what we're going to do. We're going to end that now. All right?
So he gets an opportunity to say it.
No. I stopped that. And if you want to address that in a different way, then we've got another motion in about 5 minutes that we're going to probably be talking about that. So let's talk about that then. This is I let counsel go and think it was going to wrap back up, and I didn't see that it was going to wrap back up in regards to the request. So that's why I stopped it. All right? This is not accomplishing anything in regards to the question of access to these 4 pieces of evidence. So I've got everybody's position. I've heard the arguments from counsel. Okay. What I'm going to do is I'm going to take it under advisement, and then what I'm going to do is issue an order probably tomorrow.
All right, still with us, watching along, Ali Benevento, Sonny Slaughter. Sonny, what did you make of those quick fireworks in the courtroom there? The judge saying, stop that, as if he's somebody's father. Of course, he's taking this motion into advisement here. What'd you make of that?
I thought the judge was correct, so he could tone it down, get everybody refocused. However, I'm going to always say however. From a defense perspective, and we have Ali here to talk further, the defense is doing constitutionally what they're required to do. Mm-hmm. They have to have a zealous representation of their client. So it was theatrical, but the defense is supposed to defend their client and using all the theatrics and whatever they can. However, this shows that the judge has command of his courtroom, focused on the evidence, and he is not going to let this thing get away from anybody, let alone him.
Ali, let's talk about it. Let me hear your thoughts. Is Sonny correct here?
100%. I'm going to say Ali Benevento is Team Judge Sullivan on this one, at least on that clip. I will say I agree. The defense attorney is doing his job. I was with him actually completely until the very end. There was a little bit of a superfluous comment. We could have done without that. The prosecutor, once again, as we saw her do during the arraignment, is doing too much, okay? There's a point at which you can get sassy with the court. You can be disrespectful. I thought the comment was very juvenile. It was unnecessary, and the judge shut it down immediately, as he should. But back to Sonny's point about what the defense is doing, yes, he is zealously advocating for his client. And to his point, if we are stipulating as the defense that all of these pieces of evidence are admissible, we are not contesting that she did what she did, we are not contesting the facts, then it kind of flips to the prosecution. What is your reason for doing this, if not to inflame the passions and emotions of this jury so that they turn against my client, the defendant, therefore not giving her a fair trial? 100% loved his argument, could have done without his comment at the end, and I could do without all of the prosecutor's little snippy comments throughout these proceedings. Good on Judge Sullivan. Hold it down.
You got to bring a level of etiquette and professionality to these sorts of things. When people's lives are at stake, and you're supposed to be speaking on behalf of the long-term effects on this family. So I do agree with both sentiments from you both. My friends Ali and Sonny, stick around, you guys. More of this hearing on behalf of Lindsay Clancy's ex-husband Patrick on the other side of this break. Again, he's trying to bar graphic evidentiary exhibits from the eyes of the public, including photos of his children and his frantic 911 call after finding those children murdered. The judge taking it under advisement. More next after this break. Welcome back. We've been following the case against Lindsay Clancy very closely this week as jury selection has wrapped and both sides prepare for opening statements on Monday of next week. But right now, we're taking a look at a motions hearing on behalf of Lindsay Clancy's husband, Patrick Clancy, that occurred after those 18 jurors were seated earlier this afternoon. Let's take you back inside that hearing.
Photographs. I have looked at a crime scene video, which I imagine is where the crime scene pictures will come from. And so I'm familiar with the universe of the evidence that we're dealing with right now. I want to take tonight, go over the arguments from parts. That's why I'm stopped a little bit, everybody. I just want everybody focused on that issue. So I'm going to take this matter, the request of Mr. Clancy under advisement, and I will be issuing an order in regards to that request sometime tomorrow morning. All right? Now, there's one other motion that we have to address, and I believe that is the defendant's motion to limit witnesses. Is that correct? That's the motion we have. All right. Now, what I'm going to, I've read the motion, all right? I've read the grand jury minutes from all the individuals who have scheduled to testify. So I'm going to hear from the defendant just in regards to this, and then I'll hear from the Commonwealth. So, Mr. Reddington.
Thank you. And I will restrict the hyperbole, Your Honor. This motion is asking that Your Honor would direct the Commonwealth, since apparently the Commonwealth will not agree voluntarily to restrict the presentation of a large number of first responders to this tragic incident. First of all, let's face it, firefighters, EMTs, police officers, they're all wonderful people. They're doing the Lord's work. What these people have gone through or would go through and have gone through in their jobs cannot be underscored. And that's to be respected and embraced. But to present them one after the other in this trial to testify to, and I would very briefly, I don't even have to mention their names, but Duxbury Fire Department paramedic detailed to the home at 47 Summer Street dealing with the defendant, Lindsay Clancy, treating with her outside with her injuries. The Duxbury Police Department sergeant went to the house, heard noises. Stephen Hall, there's a Duxbury Police Department officer, saw the defendant, heard screaming in the basement. Duxbury Police Department heard another individual, heard screaming in the basement, went in, saw the kids in the basement. Another firefighter heard noises, was outside. Another firefighter, Duxbury Fire Department EMT, saw Lindsay on the ground, was treating Lindsay, heard screams coming from the house, went into the house, describes the basement scene. Another Pembroke Fire Department individual, paramedic, same idea. Another Pembroke Fire Department paramedic was in the house. Duxbury firefighter EMT saw the other EMT carrying two kids out of the basement. Saw two children on the floor. Described the basement. Marshfield Fire Department paramedic went in the basement, saw the children laying on the floor in the basement, on their backs facing upward. Saw blood, what appeared to be blood around the nose of one of the children. Another firefighter, Marshfield, assisted in the basement, heard the screaming, yelling, and made his observations. Another firefighter from Duxbury in the basement saw the children, little children, wearing onesies and feeties, laying on their backs on the basement floor, assisted as he could. Another Duxbury Fire Department individual, basement. Another Kingston Fire Department mutual aid gentleman assisted in the basement, describes what he saw in the basement. Another Kingston Fire Department individual saw Pat, heard the screaming, and went downstairs, describes what he saw in the basement. Another Duxbury Fire Department individual responds to the scene, describes the scene, and then Duxbury Fire Department individual responds, saw Patrick in the kitchen, saw him sobbing, and made observations of the scene. So that was what was presented to the grand jury, and is what, from what we can see, is what the government would try to present at this trial. And I suggest to the court, without sounding as though I'm trying to minimize the horror of what transpired here and what these good employees of the municipalities had to endure and see, and probably to this day are suffering post-traumatic stress from it. Legally and objectively, I suggest to Your Honor that it serves no purpose other than to inflame or try to inflame the passions of the jury, one right after the other, offering them water, offering them time to gather themselves. And it may have worked in the grand jury, but it shouldn't work in a jury trial.
Counsel, is this motion, I understand the rationale behind it, but isn't this motion kind of a little premature? Because I mean, if you're talking about something being cumulative, don't I have to hear what the first witness says first, and then ask for the Commonwealth if there's an offer of proof? There's anything different that this witness saw or did, or is going to bring to the jury? And I guess what I'm saying, it's difficult for me sitting here right now to tell the Commonwealth you can't call witness number 2 without knowing what witness number 1 is going to say. I appreciate this kind of flags the issue for me. It's helpful. You know, I went back, I pulled out proposed Rule 403 that talks about, you know, needlessly presenting cumulative evidence, so I could be aware of that. Got the cases pulled out for that. But I don't have everything in front of me. That's what that's the way I was looking at it right now. But Commonwealth?
Thank you, Your Honor. So in a typical murder case with one victim, we would be proving deliberate premeditation and or extreme atrocity or cruelty. Either one of those, proving first-degree murder, you'd have to prove that the defendant's actions caused the death. And the way we do that is with the person finding the body, then the people who treated the body trying to save that person, then the medical staff at the hospital treating them and then declaring them dead, and then the autopsy confirming that the actions of the defendant were the cause of the death. Here, unfortunately, we have 3 victims. So that multiplies those witnesses by 3. We also have the defendant herself who was treated at the scene. So then that's a 4th.
All right, coming up, more of this hearing on behalf of Patrick Clancy, plus a quick update out of Los Angeles where singer and accused murderer David Burke is in his 3rd day of a preliminary hearing for the murder and dismemberment of an underage girl. And evidently there was testimony about a missing chainsaw from his Hollywood Hills home. More on that after this break. Gotcha.
prove.
On September 8th, police responded to a report of a foul odor coming from a car. They made a shocking discovery: human remains, the decomposing body of 15-year-old Celeste Rivas Hernandez. She would have been 15 on the day before she was found, after she was reported missing back in April of 2024. The abandoned Tesla had been parked on a street in LA. It was registered to David Anthony Burke, who goes by David on stage. He got famous on TikTok and has a young following and has been called one of Gen Z's most buzzed about artists, in part because of his hit song Romantic Homicide, a song that's now raising questions about his connection to Rivas Hernandez.
We'll get back to the Clancy case in just a moment, but first an update in the David Burke case. Welcome back to Court TV Live. I'm Cody Thomas, and today we are learning about a missing chainsaw in the murder case of that singer David. Now, we're following day 3 of his probable cause hearing in Los Angeles, where a judge will determine if the case will move on to trial. Now, prosecutors are introducing evidence to support the allegation that Burke ordered multiple chainsaws, a body bag, and an inflatable pool to dismember Celeste Rivas after he allegedly killed the 14-year-old girl. Now, the prosecution says he killed Celeste when she allegedly threatened to expose their illicit relationship, which would ruin his career. And of course, as I mentioned, we're on the ground in that Los Angeles courtroom where the hearing is happening. Julia Deng, our correspondent, has been inside for every day of the hearing so far, and earlier she reported on the multiple chainsaws that David allegedly used.
There was another chainsaw, a Makita brand chainsaw that we talked about the other day that was ordered online and delivered to David's house. As far as I know, from the evidence presented so far, that chainsaw was not located during this search. The 2 other chainsaws, and here's why the criminalist said there really was no forensic value. She testified earlier that had they been used for dismemberment, there would have been no way for blood to be cleaned up to the point where their testing did not indicate something of forensic value. So when they did that initial test on scene and there was no presumptive positive, they elected not to take those 2 chainsaws into evidence. But yes, there is a missing one.
Very interesting fact there, Julia Dang. Thank you. We'll talk more about the David Berg case coming up next hour, but let's turn our attention back to Massachusetts, where we're taking a closer look at today's fiery motions hearing in the Lindsay Clancy case. Parties were battling on whether certain pieces of evidence should be made public. All this ahead of opening statements, which we will know will happen on Monday. Let's get you back into court, picking up where we left off in that motions hearing.
With one victim, we would be proving deliberate premeditation and or extreme atrocity or cruelty. Either one of those, proving first-degree murder, you'd have to prove that the defendant's actions caused the death. And the way we do that is with the person finding the body, then the people who treated the body trying to save that person, then the medical staff at the hospital treating them and then declaring them dead, and then the autopsy confirming that the actions of the defendant were the cause of the death. Here, unfortunately, we have 3 victims. So that multiplies those witnesses by 3. We also have the defendant herself who was treated at the scene. So then that's a 4th multiplier. Then you also have Patrick Clancy, who was so devastated upon finding his children in the manner that he found them, that he was in an awful state and had to be brought to the hospital as well. So that's multiplying the people here by 5. Now, when the first responders arrived at the home that night, they thought they were responding to one victim, the defendant. Then they found out that the children were there, and they found them in the state that they were in, and it was a chaotic scene. They're asking for more help. They're trying to figure out what's going on. They're trying to treat these children, and so there's a lot of handing off. People start CPR. People move on to another child when someone else arrives who's better equipped to deal with, say, a baby versus a 5-year-old. And so we have multiple people working on these children trying to save their lives and then get them to the hospital and get them treated, and unfortunately, none of them survived. But the Commonwealth did not choose the number of victims, the defendant did. The Commonwealth did not choose the ages of the victims, the defendant did. The Commonwealth did not choose the horrific nature in which they died, the defendant did. It is not the Commonwealth putting on a circus or a parade, it's the Commonwealth presenting the evidence in this case to prove that the defendant killed those children in the manner in which they were killed. Now, if defense would like us to reduce some of these witnesses, that would mean not talking about one of the children. So if he would like to tell me which of these children don't matter.
You know what? I'll tell you, we don't need that. All right? We don't need that. The question right now for both of you is, this is a motion saying that there's going to be cumulative evidence. I don't know what's going to be presented. So how can I say that witness 2 doesn't bring anything extra after witness 1? I understand the theory. The Commonwealth, and I'm not telling the Commonwealth how to try their case. I'm not. And I guess the issue has been brought up that the defendant views the Commonwealth's approach one way. The Commonwealth views it a different way. I'm the one who's going to have to decide, and I don't have anywhere near enough information right now to determine if something violates, Section 403. But I understand the Commonwealth's position. There are a number of witnesses, and they all may very well bring something unique to the Commonwealth's case. So it's really what I'm probably going to be doing as we go through this is have everybody come over here to the sidebar, hopefully calmly, talking about an offer of proof. And is this witness bringing something? If they do, fine. I'm not restricting the Commonwealth thing. I appreciate the fact that it was brought to my attention. Now I can be aware of it. And we can just deal with it as the trial goes on. Just like, like we said, all of us have tried a number of homicides. So we know how it's done. And so I'm aware of how the Commonwealth has to prove multiple elements in every case. And so I'll be cognizant of that. So I guess probably just so you'd be prepared that the defense objection will be it's cumulative. And we come over here, and if there's some reason why there's something else that this witness brings or a reason why you want to call him, then we'll deal with it at that point.
Commonwealth will be prepared.
All right. All right. So I'm going to take no action on this, assuming that it will be raised again in the next couple of weeks. We'll deal with it as it comes up. I appreciate the parties raise. This is exactly why we have motions to eliminate. So I know that this is an issue that's coming up. I appreciate the Commonwealth setting out what their response is. So I'm kind of ready for that as well. So I'm not going to take any action on that motion and eliminate. Like I said, I'm sure we'll be talking about that a little bit later. Anything else we need to address today? Counsel?
No, Your Honor.
All right, defendant?
No.
All right. So the plan, we're going to be in recess on this matter until Monday. Parties should be prepared to give openings. I'll give a very brief pre-charge at that point, and then we will just begin with the evidence, hopefully Monday morning. And I will try to get that order out in regards to Mr. Clancy's request sometime tomorrow morning. All right. So again, I want to thank everybody for kind of helping me get through these issues today, and thank you for all your hard work on this. So we'll be in recess until Monday morning on this.
Court will rise. This matter is continued to Monday, July.
All right. Still with us this hour, Ali Benevento and Sonny Slaughter. Ali, let me begin with you. This is seemed like some legalese going on here. Based on this right here, this motion, a defense's motion to limit or restrict witnesses, arguing, that too many EMTs and firefighter witnesses may somewhat inflame the jury's passion regarding, the facts of this case. Is this a fair ask by the defense? What are you making of this? Can you break this down for us from what you just heard?
Sure. I do think it's a fair ask by the defense. There is a rule of evidence that prohibits parties from introducing evidence that becomes so cumulative to the point that it could potentially cause more prejudice than it is relevant or probative. And that's exactly what he is arguing. Now, I also understand the Commonwealth's point that this is a unique case. We have 3 victims. The same individuals with law enforcement and EMS and fire may not have responded to the same people. And so they may have additional information. But to the judge's point, man, I love this judge more every time I hear him talk, by the way. To the judge's point, you don't know until you get there. And he said, listen, first of all, we're not going to have all this nonsense. I'm going to make the decision in the moment. If we can calmly come and have a sidebar and act like adults, I will make a decision. I will be very curious. Listen, if I am Lindsay Clancy's team, I hope that prosecutor stays exactly the way she's acting now in front of a jury. We'll see if she grows a new personality between now and then. But if I'm the defense, I want her to stay exactly the way she is now, because let me tell you, as much as we don't like the way she's behaving, or at least I can't speak for everybody, a jury is not going to like that little stank attitude. They're just not.
Stank.
There's such a thing as overdoing it. She is.
Call it like it is, Ali. I love to hear it like that. Sonny, let me get your thoughts on the whole situation, your thoughts on the motion, and then maybe your thoughts again on the attitude of this prosecutor here.
Everything Ali said, I agree with. We have to balance judicial understanding, complexity, and prejudice, because it's really important to stay balanced. And the prosecution, the Commonwealth is over the top, over with the emotion. And I want to remind our courties that prosecutors and the Commonwealth, they actually represent the Commonwealth, not necessarily the way that people think they advocate on behalf of victims. They are representing the Commonwealth and in that lens and focused on the law. And she is overly stank, as Ali would say. But I really do like the judge. I think this judge has a clear command of his courtroom, a clear command of process, and this is a very hard case. I am a mother of 4. I have given birth 4 times, and I have a 3-month-old grandson. When I look at these babies, I see what everyone else sees, even if you've never given birth. We all see the compassion and understanding, and we're all hurt by this particular case. But we have a constitutional duty as the experts, as the commentators here, to stay focused with the lens on what practice and policy is. And I think, that's what we're doing. And that's what the judge is. He has to stay focused on balancing out everything and not getting emotional. And I think This is an emotional case, but we still
Mm-hmm.
have to let it play out like it is.
Absolutely. I couldn't agree more with both of you. And what I also agree with is only professional terminology used here on Court TV Live. Stank is the word of the day, my friends. That's what we're going to keep it with here. Stand by, you two. We're going to take it back to this hearing. More facts on the case up next after this short break. Keep it here on Court TV. Welcome back. A Massachusetts jury of 12 women and 6 men will decide if Lindsay Clancy was criminally insane when she killed her 3 children and then threw herself from the second story of her home. That jury was seated just a short time ago earlier today. Court is now in recess until Monday morning when we expect opening statements. Still with us discussing this case, my good friends Allie Benevento and Sonny Slaughter. Allie, I'll begin with you. Once again, Allie, one of the themes surrounding this entire trial, once you you dissect that it's 3 young children, ages 5, 3, and 8 months, a woman who might be going through, a real mental break here at the postpartum psychosis, and then a grieving father who is still standing by his ex-wife and, the forgiveness. A big theme here is compassion. But my question, Allie, is in a courtroom, where does compassion and criminal responsibility begin? The line between those two. I mean, those have to be a little bit separate, I'd imagine.
I think it begins with listening, Cody, right? You want to have jurors who are going to have open minds, who are going to listen to the evidence, all of the evidence, not just the evidence that the state shows, not just the evidence the defense shows, but listen to all of it, to weigh its credibility, to give it whatever weight they decide, and then to, again, if they approach it with an open mind, they are human beings. They probably do feel compassion for this woman. Listen, it is very clear that she was suffering in the time leading up to all of this happening. That is documented. That is not even in dispute. She was going through something. The question is, could she appreciate the wrongfulness of her conduct at the time that she took the lives of her children? That's where the jury's really going to have a tough time. They are going to have to not look past, but they are going to have to be willing to set aside the horrific nature of this crime and how these babies lost their lives at the hands of their mother. And they are going to have to say, is there a medical, psychiatric explanation for this that satisfies me such that my verdict should be that she is not criminally responsible for her actions, even though her babies died at her hand? That is tough, but I think the answer to your question is it begins with an open mind.
Absolutely. My dad always says your mind has to be like a parachute. It only works when it opens. Sonny, let me. You like that one, didn't you, Sonny?
Good one.
Sonny, let me ask you here. Though we have to go in with an open mind, and of course, I never, ever, ever want to victim blame or cast aside any sort of mental illness type of situation. But Sonny, when you have a situation here where the prosecution has, presented some evidence of, her looking up the distances on the Apple Maps between, when Patrick is going to the fast food place, to the CVS and back home, and she's looking up, all these different routes, and conveniently this happened in the window of time that she allegedly sent him off to go on these routes. It seems maybe just a little bit calculated. I'm sure it's going to be an uphill battle as far as, the defense trying to overcome that.
Oh, absolutely. Yes, because what jurors are also going to have to be weighing is, was this planned in any form or fashion? And then that takes away from some of the psychosis when you're not talking about the amount of medication that she may have been on. So I want people to think about how many of us operate, and we've seen this in other cases where somebody might be, they might have drug use and then there's drug abuse, but they are still operating and moving coherently every single day operationally. It doesn't mean that they don't have impact from this, just like it doesn't mean that she didn't have impact from this. But could she, as Allie spoke so cleverly and consistently, could she really separate herself from the actions and be criminally responsible while at the same time have this psychosis which impaired her enough to do the actions that she did? And hopefully that makes sense to the public.
Yeah, and Allie, with all of that, I still feel like there might be a slight concern that jurors could confuse a medical diagnosis with the legal standard of criminal responsibility. And what I mean by that is, just because you're diagnosed with some, mental illness or mental health condition doesn't automatically make you immune to criminal prosecution.
Correct. It has to, however, be the cause of the inability to appreciate the wrongfulness of your actions. So it's really a two-part test. Were you, in fact, suffering from this mental illness or this bout with acute psychosis such that your ability to conform your conduct to the law was gone, right? And so there is a risk that the jury might say, well, it's very clear she was mentally ill. And my understanding is in Massachusetts, they don't have any middle ground. Other states, I practice law here in South Carolina, we have something called guilty but mentally ill. Someone can plead that and a jury can find that. We don't have that here in Massachusetts. So it's kind of an all or nothing, right? The jury can find her guilty of premeditated murder, or the jury can say that she's not guilty by reason of not being criminally responsible. So it's also a little bit tougher because they don't have that compromise. Sometimes people view guilty but mentally ill as a bit of a compromise or a middle of the road. So this is a really big ask for this jury. But yes, there is a possibility they can get confused. The only thing that I would say to that is it's pretty clear.
We got to take a break here. Both of y'all are sticking around. We're talking Lindsay Clancy and David Burke. Both guests are sticking around next hour. Keep it here on Court TV.
Sorry.
Oh, good. Y'all got me? Gotcha. Perfect. Thought Allie was wrapping up, and she started going to a different topic. I was like, wait, no, my friend.